Mr. Mina's client has made several threats out loud, even in the hallways of this court,
So, ma'am,
to burn the house down.
Brian Palmer versus Sonia Stoneburner.
Ellis Friedman for the plaintiff.
Your name?
Sonia Stoneburner.
All right. I have before me a consent order for conditional dismissal. Is that what we're doing today?
Yes, Your Honor.
I thought everything was
Pardon?
I thought everything was fine. I didn't even know I had court until yesterday at 4:30 when somebody called.
Okay, you signed this conditional order of dismissal?
Yes.
All right. Did you have any questions regarding it?
No, sir.
All right. And you understand everything that's contained therein?
Yeah. Yes, I think. I haven't been living there at all. I moved
Pardon?
out. I've been moved out. I thought everything, when I signed the paper, he gave me the $1,500 out of the home.
Okay, so all of the conditions in here, you're moving out as well as the $1,500. That's already happened?
Yes, sir. Everything happened. And then I paid the defendant because I couldn't move out the time frame. So I had a lot of people there with me, including Attorney Dave, and we were moving things out, and he had me pay him $50 because I told him I may not be out by that specific day. He agreed right there, and he gave me to the original order of May 5th, and I've been out way before that.
Since that
Yeah.
time.
Yes,
Okay,
sir.
so I will
Fine.
then sign off on this conditional order of dismissal. It seems everything's done.
Yes, sir.
I will, and I have to advise you have 3 business days to think about this. If you think that there's some legal reason, some right you didn't assert or some confusion on your part, you'd have to file a motion with the court within that time frame. Doesn't mean I grant it, but you have that time to file it.
Yes, sir.
Okay?
Yes, sir.
All right. Thank you.
you
You
so
have a great day.
You too.
Thank you, Your Honor.
Thank you, Mr. Friedman.
This opening
Jeff
hearing may look routine, but Judge Simpson is carefully protecting the integrity of the agreement before approving it. A conditional dismissal is more than paperwork. It tells the court that both parties have voluntarily resolved the dispute and that certain obligations have already been satisfied. Notice how the judge doesn't simply rely on the signed document. He personally confirms that Ms. Stoneburner understands its contents, acknowledges moving out, and confirms the payment arrangement was completed. That creates a clear record showing the agreement was entered knowingly and voluntarily. The 3 business day warning is equally important. The judge isn't suggesting something is wrong with the settlement. He's ensuring that neither party can later claim confusion without first using the proper legal procedure. That extra explanation protects both the litigants and the enforceability of the court's order. Did you notice that the defendant volunteered additional details about paying an extra $50 and moving out early? Those facts weren't legally necessary to approve the dismissal, but they reinforce her credibility by showing she was trying to demonstrate good faith compliance rather than avoid responsibility.
Jeff Lewis versus Jennifer Loudon.
Morning, Your Honor. I don't think Jennifer Loan has arrived or plans on coming, for that matter.
What are we on now?
Subpoena was served.
What is this up for? It's set for creditors exam.
This is debtor's exam, yes.
Oh, that's Miss Lewis. Okay. All right. And she's not appeared. I thought I had issued a default on this. Okay. She's not here. All right. So what I typically do in these cases is that then I will issue an order to show cause. From that order to show cause, then I would issue a bench warrant if she doesn't appear.
Okay, sounds good, Your Honor. I have a question. Can I approach the bench?
Yes, you can. I didn't say so on the record. We'll set it for June 2025, 9 a.m. Court calls the case of Cross Street Properties versus Garrett Gate.
Good morning, Your Honor. Parista Gazari appearing for plaintiff.
Eric Davis or Luke Hanna?
Your Honor, we actually resolved the case as to defendant Hannah and dismissed that party only
Yes.
from the case.
Did you see that?
So today we're seeking to proceed as to defendant Davis. I filed a motion for entry of default judgment as to that defendant. Notice of the request for entry of default judgment was served at least 7 days before the requested entry today in accordance with MCR 2.603 B1B. But just so the court is aware, the motion was filed 8 days before today,
Got it.
so that it's clear. But he has not appeared. This case started as a summary proceedings for possession and money. Then defendant subsequently moved out. We amended the complaint to add money damages. There was extensive damage to the property. And here we are.
And you're requesting a judgment in the amount of $8,093.
No, Your Honor, actually, the amount has increased. So the property has not been re-rented. It has been listed, but it has not been re-rented right now. The total amount of damages is $16,111.42. There's court costs of $397.10. The statutory $75 attorney fee for a total of $16,583.52. And that is after application of the security deposit.
That's after the.
Yes.
Okay. All right. Garrett Davis? Hearing no response based upon the motion that has been filed, as well as the indication from counsel, court will enter a judgment as requested by default.
This
Thank
is
you,
one
Your
of the
Honor.
most legally significant moments in the hearing because it demonstrates how a default judgment operates. Many people assume that if a defendant doesn't appear, the plaintiff automatically receives whatever amount they request. That's not how the process works. Even without the defendant present, plaintiff's counsel still walks the court through the procedural requirements, explains why the complaint was amended, accounts for the security deposit, and identifies every component of the requested damages. Judge Simpson also pauses before entering judgment, calling the defendant's name one final time. That small procedural step matters because it confirms the opportunity to appear was provided before the court acts. Due process remains important even when one side is absent. Another detail viewers may overlook is the increase from the original damage estimate. Counsel explains that the property still has not been re-rented, meaning additional damages allegedly continued to accrue. Whether those damages are ultimately collectible is a separate issue, but procedurally the explanation supports the updated request before judgment is entered. Would you have challenged those numbers if you were the absent defendant? Missing a hearing doesn't just mean losing the argument. It often means losing the opportunity to dispute the evidence altogether.
Thank you, Your Honor. I will submit the judgment electronically.
All right, very good.
Thank you.
BNC Rio versus Nettie Whitlow.
Good morning, Your Honor. Ian Redmond, P70599 on behalf of the plaintiff.
And greetings, Your Honor. Emmett Greenwood on behalf of defendant P56556.
Okay, good morning.
Your Honor,
Yes.
a new bankruptcy was filed yesterday afternoon, so we are not looking forward to doing anything today other than informing you of that bankruptcy.
All right. So what I will do is I will administratively close the case and pay the matter.
And then if and when this reopens, we will do the same thing that we did a couple weeks ago.
So great, you'll be back, huh? No, go ahead.
Well, no, Your Honor. I'm just would court entertain my motion to withdraw from this case.
Yes, I mean, if you file an order with the court, I'll sign an order of withdrawal.
Okay.
I
It
have
has
no
nothing-
objection at
All right.
all. I would say that since this is administratively closed, depending on what the engagement was, the engagement may be terminated as of right now.
Right, but I think what would happen, well, I don't know, because do we have?
I'll just submit
counsel
order.
listed?
We do have Mr. Greenwood listed.
All right,
I'll submit
so
order.
submit an order to that effect. All right, thank you.
All right, thanks.
Sycamore Meadow versus Autumn Meadow.
Good morning, Your Honor. Attorney Carrie Green, this is 729.
Good morning, Your Honor. Emily Brule, P8827, defendant.
All right,
Judge, I did give counsel updated ledgers this morning. I got them late yesterday, so I did hand for that and any of the research that we have that they requested.
all right.
So, Your Honor, Ms. Meadows was told by the Sycamore front desk that she should just hold on to her money orders until they got things straightened out. So now that we know that things are on their way to getting straightened out, she just needs to give her money orders for the past couple months, get a fresh ledger, get that ledger to emergency housing fund, and we should be able to get this all resolved.
Okay,
On the pathway to the finish line, Judge.
halfway to the finish line? Okay. As long as we keep running in that direction, we'll be good. Um,
Judge agreed. And I,
because-
I apologize to the court. You, obviously, it's not me, but I do apologize as I'm standing here representing them. And we all know I don't like being in.
No, I know, and it's a process, right?
for sure.
So you guys need a date out.
I think at least 3 weeks for
That's
everything.
fine. I'm good with that. Okay.
Will June 10th work?
Works for me. That works.
All right. So I'll adjourn this to June 10th, 2025 at 9 a.m.
Thank you, Your Honor.
Then Sycamore Meadows versus Derek Hall.
So Emily Rule for defendant.
And Attorney Carrie Bannon on behalf of plaintiff, Your Honor.
Mr. Hall has moved out. We do, however, have counterclaims, and so we would like that to be transferred to the civil docket. We're also waiting for hopefully a resolution.
Well,
of that.
that'd be transferred to what? The civil docket?
That was my understanding of what would happen.
I don't know how that's the thing. I guess we could bifurcate the possession if he's vacated.
Well, the civil docket would normally be handled by Judge Barr. This is not going anywhere.
Okay.
So if you want to call it the civil docket, call it the civil docket. I don't care. So you still have your counterclaims.
Yes, and our concern is just for protecting defendant's credit, getting that down to a number that he agrees to, and then he will pay.
You send me a
that
number.
I did give, but yeah, I will.
Will you send?
I will send everything.
Okay, send me a number and I'll take it to my client. Judge, hopefully we'll be able to resolve this.
June 10th, 2025, 9 a.m.
Thank you.
Sycamore Meadows versus Vernon Jantz Jr.
Again, Carrie Zannon on behalf of plaintiff. I'm actually handling your court officer assigned conditional dismissal on this one. It's my understanding Mr. Jantz is going to vacate by June 10th. Both parties have signed that.
That's correct, yeah.
That's correct. Since counsel is on this. This case is conditionally dismissed. They've signed that. Sycamore Meadows versus Curly Fulton.
Emily Rule for defendant.
Carrie Zannon on behalf of plaintiff.
So for this one, we do have some concerns with the ledger. I did not know that plaintiff was going to have updated ledgers, and so I am not prepared to argue everything. I apologize to the court for that.
Judge, I'm okay with June 10th on this one, if that's okay with you.
So I just want to make sure where we are on it. You got the updated ledgers
Yes.
now, and you think there are some discrepancies.
Yes, I believe there's a 1420 overcharge.
1420, are you saying 1,420, or are you saying $14.20?
1,400.
Okay.
Oh, because if it's the 14,
Because if it was
that-
1420, Alan would pay it. No.
I would pay it now.
Okay.
Alan doesn't need to.
Oh, okay. All right.
I didn't know Alan provided rental assistance.
No,
Neither did Alan.
sometimes I just spend his money. It's just the way it works. Okay, so June 10th.
Please.
All right, I'll adjourn this at June 10th, 2025, 9 a.m. Thank you, man. All to the Bank of Felicia. Sycamore Meadows versus Clarissa, is that how I pronounce it? Nichols.
Emily Rule for defendant.
Carrie Zannon on behalf of plaintiff.
And for this one, now that we have a ledger, we just need some time to get into it.
Okay. June 10th, 2025, 9 a.m.
Thank you.
Sycamore Meadows versus Kala P. Kayla P.
Good morning, Your Honor. Jill Bauer on behalf of Ms. P, who is also present.
Ms. P.
All right, where are we on this?
As we have the motions, I believe, up today, I filed a motion for entry of judgment. I know that you've read them.
Yes.
And I know that counsel filed a response to the motion for entry of judgment. She also filed a motion to dismiss as I filed a response as well. I know that you've read everything, unless you have any questions. The only thing that I would briefly say is that two things as to the health hazard that they're like, well, Judge, I don't know how you want to do this. I guess I'll stop talking and leave that part to you. And
No, go ahead.
Judge, my motion for entry of judgment is no triable issue. Partly that is, the things I wanted to add is the arguments that they're making in their response and their motion to dismiss our legal arguments. So as to the jury trial, I don't believe that any of this is a jury trial issue. I think this is an issue for you to decide, whether it's in our motions or whether it's at a trial. So I wanted to put that out there first, because I truly believe, going over everything that has been filed, that's where we're at. As to the argument as to the health hazard, they claim that the health hazard was improper and it should have been a different notice. I would argue that where HUD is silent, state law trumps, and that's what this is at this point. And then the only other thing I wanted to add is the health, the 7-day was never cured. They had a chance to cure, and that's why we're standing here, because it wasn't cured. And I think that's all I have to say at this point.
I just want to make sure, I thought we were gonna ask. If
Oh, do you want to do that first? Oh, I didn't know.
We talked about asking if you wanted to speak with us in the back to.
And I'm
talk
still
about it
agreeable
more
to-
fully, but.
Sorry,
when
you said you wanted him to rule on the motions, I figured you wanted that first, but if you wanted to talk first, I'm good with either, Judge.
What would you prefer, Your Honor?
Poor Judge.
I haven't said a word.
You
All
called
right.
the case, Judge.
Yeah, I did. So why don't I do this? Let me pass it. I'll talk to the two of you back. and see if-
Thank you.
Ms. Bauer could have stopped you at any minute, but she just didn't. And then she goes, but I thought, no, never.
Well, I wasn't sure if you were winding your way to that.
Winding? Wow.
Oh, is that?
Jill, I go straight in.
That's right. That's
No, I
right.
don't lie.
She's winding into that.
Sorry.
All right. Court recalls the case of R&J Group Holdings versus Saffield et al.
Plaintiff is ready, Your Honor.
Counter plaintiff is also ready.
All right. Where are we on this, folks?
Good morning, Your Honor.
Good morning.
God bless you, Your Honor.
I have tried to figure out exactly where our posture is on this case, because I received 2 emergency ex parte motions. Have those, counsel? Pardon?
No, I received one some time ago for an adjournment that's long since come and gone.
No, these were filed yesterday.
I have no such, I haven't been served with anything. I had no idea those were even in existence.
Well, and I'm trying to figure out, why are they ex parte? Why is the request ex parte?
Permission to speak, Your Honor?
Yeah.
Okay, good morning. They are ex parte because the order that Your Honor signed for $5,000 a month bond escrow, we are trying to revise that to $250,000 refinancing proceeds of another property.
Is this case currently before the circuit court?
It is currently it's been appealed. Your Honor's judgment has been appealed, and we filed a motion to dismiss the appeal. It's still pending, but that's all I can tell you about that, Judge.
So we'll get copies of these to you, but that's what I'm not clear I understand these motions, because the first motion is to have a lending institution. You want the bond changed from $5,000 a month, which was the escrow order.
Correct.
To customarily then become your bond on appeal. You want that changed to a $250,000 bond.
Correct. And may I speak the reason?
You can, but I'm not even clear that at this juncture, I would have the jurisdiction to do that. Because I think you would have to request that of the circuit court to change the bond. I've set the bond when the case was before me. It's appealed. That, in my understanding, that's the only thing I can do once the appeal is filed. I can set the bond on appeal.
Likewise,
after that, it's the circuit court. So I don't even know that I can address this. I would also note, counsel, and like I said, we'll get you a copy. There's also this motion to have the R&J Group Holdings pay $250,000
Escrow bond.
for an escrow bond, I don't even know what that, they were the prevailing party, so I'm not even sure how that works. But,
Yeah, I can't comment on, I haven't seen any.
I know, and that how these got on. I set this for a hearing on the escrow.
That's what I was under the impression was here today.
I didn't know anything about it. They are not on this document.
For the payment out of the escrow? Is that what I set it for? And I'm not gonna, well, the appeal is still pending, correct?
Correct.
The court set the hearing and I called the court.
Yeah,
Said that they
I'm
wanted
not
us to come.
sure
So
why did I do that?
When is the hearing?
I must have been under some determination that something had happened with the appeal, but you're telling me it did not.
no, the appeal is pending in the circuit court on this matter.
Okay, then I can't do anything with escrow, so,
May I ask you a question, Your Honor?
sure.
Okay, Mr. Mamina's client has made several threats out loud, even in the hallways of this court,
So, ma'am,
to burn the house down. Does the court have authority to issue a PPO against him? I am protecting 4 underage children, my mother on the wheelchair. I don't want him to burn the house because we have a pending case. It's totally out of order.
Your Honor, that's preposterous.
No, it's not.
It's
You even
absolute-
heard.
I didn't hear anything like that. I
Oh,
don't,
yes,
I've heard,
well, a lot
I've
of
seen a
people
lot
did.
of things in this case I've never seen before, including ex parte motions seeking a $250,000 bond. That's
Yeah,
That's
it's a breach of
preposterous.
contract, sir. This is a breach of contract case and a jury demand.
everybody done? No, I can't deal with anything. I have no jurisdiction. The jurisdiction at this point of this case rests with the circuit court.
Yes,
So-
thank
Are
you.
you denying the ex parte motion?
I am,
Or refer.
yes, I'm denying them because they are improperly filed before me. Because I can't do that. You'd have to file those with the
Yes,
circuit.
we'll do that, Your Honor.
All right,
Thank
so,
you.
all right,
Thank you, Your Honor.
thank you.
The final exchange highlights one of the most misunderstood principles in civil litigation: jurisdiction. By the time this dispute reaches its conclusion, Judge Simpson is no longer evaluating whether anyone's underlying claims are right or wrong. Instead, he's deciding whether his court even has the legal authority to act. Once the appeal is pending in circuit court, the trial court's power becomes extremely limited. That is why he repeatedly returns to the same point. Regardless of the allegations, requested bond changes, or emergency motions, he cannot issue orders beyond the authority the law gives him. Notice how the hearing briefly shifts into accusations about alleged threats. Those claims may sound serious, but Judge Simpson refuses to let the discussion drift into matters that aren't properly before him. Rather than reacting emotionally, he separates jurisdiction from substance. That's an important judicial discipline because courts must resolve issues through the correct legal process, not simply because allegations are made in the courtroom. Across this entire docket, we see the same pattern. Settlements are carefully confirmed, defaults require procedural compliance, bankruptcy immediately affects pending litigation, adjournments are granted to ensure accurate financial records, and appeals shift authority to a higher court. The consistent lesson is that procedure often determines outcomes just as much as the underlying facts. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.